In this lesson, we'll cover sections 10, 11, and 12, which explain what happens if a dispute arises between the buyer and the broker and how those disputes are handled. Section 10 addresses attorney fees, explaining the general rule that each party is responsible for their own legal costs and when that rule can change. Section 11 covers management approval, giving the broker or manager a short review period when an associate licensee signs the agreement on the broker's behalf. Section 12 lays out the dispute resolution process, including the requirement to attempt mediation first, the consequences of refusing mediation, the types of disputes that are excluded, and the option to resolve disputes through arbitration if both parties agree. These sections are designed to reduce conflict, encourage early resolution, and clearly define the process if disagreements occur. In this video, we'll walk through each section step by step, breaking the legal language into clear, practical explanations you can confidently understand and explain. Let's begin with Section 10, Attorney Fees. Section 10, Attorney Fees. This clause says that if there is any action, proceeding, or arbitration between buyer and broker arising out of the agreement. 1. Default rule. Each side pays their own lawyer. No automatic winner gets attorney fees built into Section 10. 2. Important exception. Check 12A. If someone refuses mediation or files suit without attempting mediation and then loses, 12A can shift attorney fees to the non-mediating party. Section 11, Management Approval. If an associate licensee, salesperson, or broker associate signs this agreement on behalf of the broker, then the broker or manager has the right to cancel the agreement in writing within 5 days after it's executed. 1. This protects the brokerage. It allows management to review the agreement for compliance with broker policy. 2. 5-day window. The clock starts after the agreement is signed/executed. 3. Must be written cancellation. Verbal cancellation is not the standard here. Written notice is required. Section 12A, Mediation. What 12A requires. Buyer and broker agree that before arbitration or court, they will first attempt to resolve disputes through mediation. Section 12A requires mediation before arbitration or court. The mediator fee is shared equally. And here's the important part. If someone refuses mediation or files without attempting it and then loses, they may have to pay the other party's attorney fees, despite the general rule in Section 10. Section 12B, Additional Mediation Terms. Excluded matters. What 12B is doing. It lists certain matters that are excluded from the mediation requirement, including items like 1. Foreclosure-related actions to enforce deeds of trust or similar. 2. Unlawful detainer, eviction. 3. Mechanics lien filing/enforcement. 4. Matters within probate, small claims, or bankruptcy court jurisdiction. It also explains that filing certain court actions for provisional remedies, like attachment, receivership, injunction, or recording a notice of pending action, does not automatically waive mediation if the party promptly requests a stay while mediation proceeds. Section 12C, Arbitration Advisory. If buyer and broker want to resolve disputes through arbitration instead of court, they can document that agreement by attaching and signing an arbitration agreement, CAR Form ARB.